Good afternoon and welcome to Lex Cognoscenti's Rendezvous series. And it is our second season. After a hiatus of almost 5 years, we are back with yet another season of Lex Cognoscenti's Rendezvous series. I hope you all remember us in 2021 as final year students. Myself, Jyoti Prakash Dutta, and my friend Debashish Kumar Panda had started this series with a vision to make a bridge between legal luminaries and grassroots level law students and lawyers. So, with that vision, we had hosted many dignitaries like senior advocates, former judges, additional solicitor general, advocate general, and advocate on records. So, with that vision, we have also resumed this series after 5 years. So, we hope that you will also give us that much support that we had received 5 years ago. Without any further ado, I want to introduce you all to our first guest of this series, Mr. Nishant Verma, Advocate on Record, Supreme Court of India. Sir, thank you for accepting our invitation without any conditions and terms and conditions, and readily accepting our invitation to be our guest in the second season of Lex Cognoscenti's Rendezvous series. Thank you, sir.
Thank you, Jyoti. Thank you. It's my pleasure to connect with all of you.
Thank you, sir. Pleasure is ours. So, sir, as we know that you have traversed a very inspiring journey from a very small place in Bihar to the apex judicial institution of this country. So we have a brief idea about how you have traversed that journey and you have traveled so much of ways to the top judicial institution. But if given a chance, how do you introduce yourself to our audience?
So, you may call me first generation or you may call me second generation lawyer. I don't know. But my father was a lawyer. He died when I was 6 years old. Along with my mother, they died in a mishap. I was born and brought up in Chhapra, Saran district, Bihar. I have studied from there. I did my matriculation from Chhapra. I then after I came to Patna for 10 plus 2, and then after I did my graduation in economics from IGNU. Then after I had a setback. I had a tragic setback. My both kidneys were failed. I had gone on kidney transplant in December 2019. No, December 2009. So then my family members told me to do LLB. So then I take admission in LLB in 2011. I did my LLB from 2011 to 14. I have practiced 1 year in. I had practiced 1 year in Patna. My sister was living there in Patna. I lived there in Patna, and I have practiced there in Patna District Court and High Court along with one of my esteemed senior. He was my friend's father. I had joined his chamber, and after realizing that there is not so much growth in Patna because cases were filed in a very limited jurisdiction like writ or civil or criminal. There were no NCLT, no arbitration. There were limited scope in Patna. That's why I wanted to come to Delhi. Took help of one colleague, one senior colleague. He inspired me to come to Delhi, and I came to Delhi and started practicing here with recommendation of him. This is my brief journey till now. I became AOR in 2020, 2022, and he helped me in getting AOR certificate. I'm practicing AOR for more than around 4 years. Around 4 years.
Sir, you said that your family members suggested you to pursue LLB.
Mm-hmm.
So recently, former Attorney General Mr. K.K. Venugopal, Learned Senior Counsel, he has written his memoirs and titled it as an accidental lawyer. So
mm,
many senior advocates are there in the Supreme Court as well as in high
mm,
courts, and we have
mm,
hosted a lot of them.
mm,
So they have told us that when they were in their college days, they were not
mm,
actually certain about pursuing law.
mm.
They were thinking of some other things, and accidentally they landed up in law. So, what was your case? Whether you were certain that you were going to pursue law, or whether it was purely a recommendation made by the family and not your choice?
See, I was not. I was an economics enthusiast. I did my graduation in economics earlier before pursuing LLB. I had passion for economics. I wanted to do my higher studies in economics. I wanted to study from Delhi School of Economics. I have a certain principle that I will make my aims step by step. I don't make aims quite far. So I I go step by step. I don't have any dream. I didn't have any dream to become a designated senior advocate or become a quite good economist in India. It was simple aspiration to become a economics, but after getting suggestion from my brother-in-law, elder brother-in-law, he told me that your father was lawyer and you have a physical limitation since I take so many medicines. So he told me that legal profession will help you recognition. You will get confidence when you stand in court. It was economical also. The LLB was economical compared to MBA or any cost of living to pursue in Delhi. And I will have to prepare for the DSE economics entrance exam. So that was I knowing that I will have to again come to Delhi and I will have to prepare for entrance exam. So that's why comparing both the courses available that time in my mind, I decided to pursue LLB because LLB is a professional degree. It will, if I knew that if I work hard, I will grow. It happened subsequently, a step by step. Not everything was destined. I have worked very hard when I came into practice. I have worked very, very hard. So it was almost a destiny that I did my LLB and I progressed slowly. It was not well planned that I will certainly pursue law profession.
That's great, sir.
Mm,
So, when you were in your law college,
mm,
there are so many subjects in law. So,
mm.
which areas of law actually interested you the most?
Constitutional law. I am interested in constitutional law. But initially, I didn't get any matters for constitutional law. But I have good interest in constitutional law. It's very interesting
Okay, sir.
subject.
Yes, sir. And that is quite relevant as well because you are an advocate on record in the Supreme Court of
Mm.
India, and that is
Yes,
something that is very related to constitutional law. And each and every day, you have to deal with constitutional matters.
yes.
So
Article
that is
31, 36, 139 transfer petition, Article 32 petition, writ petition. These are all constitutional provisions.
indeed, sir.
I'm
Indeed,
actually practicing. I'm actually practicing constitutional law.
indeed, sir. Sir, when did you uh, completed your law degree and registered yourself in a bar council?
I completed my law degree in 2014. I did 3 years LLB, and in 2015 I passed AIB. I got certificate from Bar Council of India passing AIB. So I enrolled initially in Patna. I have practiced 1 year in Patna. Then I get my enrollment transfer from Bihar to Delhi in 2018. I got my enrollment transfer from Bihar to Delhi in 2018. I I had came to Delhi in December 2015.
That's interesting, sir. So, how was your junior days at the bar? Whether it was quite interesting to pursue juniorship at the bar, or whether it was struggling days?
Initially, practicing as a junior is very struggling. And if somebody studied from premier college, or he or she has studied from uh, more or less a good college, then he will definitely have advantage. He or she should have command over the subjects that they have studied. Then definitely it would have advantage. It's also depend litigation also depends upon the contacts develop, how you are smart, how you can retain a client, whether you were able to where you were able to file a case in district court or any tribunal if any client came to you. It's all about understanding the procedural law, because everything depend upon your knowledge of law and its application of law. So it's both conditions, both prerequisites are necessary to become a good practicing lawyer. But the problem is that lawyers will have are depending upon seniors, and seniors will have should have that willpower, that they want to make a good bar, good advocate arising from their chamber. This is the necessity that seniors must assist their juniors voluntarily or actively, proactively. If seniors do not help their juniors, it will be very difficult for junior members of the bar to rise in the profession.
Okay, sir. So it is said that first are always special. So do you remember what was the first case you handled independently, and the first case you argued before any court or forum?
Yes, yes, I have practiced. I have handled my first case in district court. District court, I had filed a suit, commercial suit, on behalf of a company. That company belonged to my friend's company. It's a friend's company. I had filed my first suit, and after learning and asking from senior, I pursued that case diligently. I won that case. Won that. I have 100%. I don't have too much cases in district court, because my focus is mainly on Supreme Court. But as of now, also I have cases of district court and high courts also. So I did my first case in district court, and I won that case. I took assistance from senior colleagues, and this is how I won the case. It was a commercial
This
suit.
is quite interesting. Indeed, sir. This is quite interesting and inspiring as well, because you have traveled from district court to Supreme Court level.
Yes, yes, I
And
have
for our viewers,
practiced in all forums, and till now I am practicing in all forums, particularly in Delhi. I go to district courts, I go to high courts, I go to Supreme Courts, and I'm frequently arguing in all three forums.
that's quite interesting, sir, because our viewers base viewers are particularly based in Odisha. Most of the viewers are based in Odisha, and it is definitely inspiring for them, because they are also students. They also want to practice in courts, and they have also aspirations for becoming advocate on record. But it is also a message for them that they also should practice before the district courts as well, because that is something stepping stone. And after
I am
practicing in the district courts,
I am
it,
saying
it
this because if you don't practice in district court, now you will forget all the provisions. You will forget all the provisions if you don't practice in district court. And all the civil suits, entry cases like Order 7, Rule 11, Order 7, Rule 10, Order 9, Rule 13, these applications under these provisions are all filed in district court. If you don't remember these provisions and somebody asks you randomly what is 710 or 711, how will you apprise him or her? Well, it's very much necessary you know the basic provisions of the law. But if you start practicing only in Supreme Court, you will forget the provisions. And I do not want to forget these provisions, because cases fundamentally arises in district court. F- FIR lodged in police station, then cases come to magistrate court or sessions court depending upon the offense. And this is how the criminal cases arises and goes up to high court and then to Supreme Court. So you must know how cases are being filed in district court and how cases travel from district court to high court and then to Supreme Court. Because if you don't know the procedural law and substantive law in district court, you won't become a good advocate in Supreme Court also, because your drafting will be shallow. You cannot make a good drafting. If you don't know the basic provisions of law, you cannot interpret the provisions of law. This is why I want to practice in district courts also. I am getting good number of cases in Supreme Court, but I want to go to district courts also. It's very much necessary, else you will fall short of many things.
Right, sir. So, sir, as we know that you are an advocate on record, so when did you decide that you want to become an advocate on record? Whether it was just by chance or you strategically decided that you want to prepare for advocate on record examination and then you did that.
It was my 3 years practice from 2014 till 2017. I was doing a juniorship in a South Delhi chamber, litigation chamber. So they had filed SLP, and I came to know that and the cases are being filed through an AWR, and AWRs are very much needed to file cases in Supreme Court. In 2017, I came to know that there is an exam to be passed for becoming an advocate. In 2017, I decided that I will also give an exam when I will be eligible. I became eligible in 2019 and I started training in 2019 for AOR exam. It was in 2017. After 3 years of practice, I decided to become an AOR.
Right, sir. So, sir, what are the eligibility criteria for an advocate on record and what is the exam pattern?
See, you must be enrolled in any state bar, be it Orissa state bar, be it Karnataka state bar, be it Assam state bar, be it any state bar. You must enroll first yourself in state bar council, and your enrollment date from the state bar council will be counted. It will be counted from the starting date, and that suppose your date of enrollment in 14 September 2022. So 4 years from 14 September 2022 shall be counted for initiating training under senior AOR. As you complete 4 years of enrollment or 4 years of experience, you can start training under senior AOR who has been senior AOR for more than 10 years. The concerned AOR must have completed 10 years as an AOR. Then only he can give you training. You will have to commence training under senior AOR after completion of 4 years as an advocate. And you will have to do training under him for 1 year, complete 1 year, 12 months, and then after you become eligible to sit for AOR exam. And this is basic eligibility 4 plus 1, 4 years from date of enrollment and 1 complete year for under training under senior AOR. For training under senior AOR, total 5 years to sit for AOR exam. Then you will have to pass AOR exam with 60% marks, aggregate 60% marks.
Right, sir. So, sir, there is a Supreme Court rule of
Hmm.
2013 that
Hmm.
is quite the basic syllabus for
Hmm.
Supreme Court AOR examination, as far as
Yes, yes.
I have not. So,
Hmm.
apart from Supreme Court rules, what are the syllabus for the AOR examination?
See, there are 4 papers. First paper is practice and procedures. You will to read constitution, particularly about the jurisdiction of Supreme Court, Article 32, Article 131 to 145. This is basic jurisdiction of Supreme Court. And you will have to read from the handbook of practice and procedures. So they are mainly asking practical questions that what is the jurisdiction of Supreme Court, so what is speaking, non-speaking rules, what is Article 141, what is the power of court under Article 142. What they may ask what is obiter dicta, what is ratio descendi. These questions are asked in small marks of 2 3 marks. So this is the practice procedure is first paper. Second paper is drafting. So they will give you template of questions, and you will have to draft 4 or 5 petitions in 3 hours. It may be SLP, it may be writ SLP civil or it SLP criminal. Ye- They may ask you to draft SLP. They may ask you to draft writ petition or Article 139 petition, transfer petition. Transfer petitions are filed in under Article 139. They may ask you to file a statutory appeal arising from appellate tribunal like NCLAT order if challenged under section 62 of IBC. It will be filed in Supreme Court. So, mainly these type of petitions are generally filed in Supreme Court. So for draft, these two I have explained two papers, and third paper is professional ethics, advocacy and professional ethics. To whether you eligible to practice in Supreme Court as per your conduct. Do you have any criminal antecedents? How what is your conduct in society also? Whether these how will you handle cases if there is any conflict of interest? So they may ask such type of questions. How how you, whether you will take any case if um, any person came to you and asked you to came to you after committing murder, that I have committed murder and please file my case. These type of questions are asked in professional ethics paper. To duty to court, duty to opponent, duty to opposite counsel, duty to clients. Section 49 1C of professional conduct and ethics. This is very important part of Advocates Act. So they may ask these questions from in advocacy and professional ethics paper. And one additional question they ask from contempt of court, because knowledge of contempt of court act is very much important in practice and procedure paper and professional ethics paper. And fourth paper is leading judgments. So court will provide you list of 84 judgments. At my time when I appeared for exam, there were 64 cases. Now there has been 84 cases. They will provide you list of 84 cases. It is publicly available on Supreme Court website also. And you will have to study the judgments in detail. And they will ask you to write 5 judgments or 4 judgments in detail. So these are the 4 papers that a candidate should prepare for AOR exam. Thorough preparation is required to pass AOR exam, and if you honestly study all these papers, then you will become a very good advocate, because it will make you a good not only a good AOR but also a good advocate also, because AORs conduct themselves in a very proper way as I see in my these 4 years. So there will not be any problem in any forum if you practice as an AOR. This is the basic syllabus of your exam. 4 papers, 100 marks each, 3 hours will be given to you for writing exam. Yes, one thing I want to add that one half an hour extra shall be provided to you in drafting paper. So, so there you will have to read the questions paper, for which half an hour shall be provided to you. And one thing I also want to add that they will provide you book also, Supreme Court reports in leading cases, but it is not helpful that way, because you will not have that much time to refer to book. So if you write answer on your in your own language, it will be helpful to you. There will not be much time to refer to books, Supreme Court reports. It will enlist all the judgments that are being provided, that have been provided to you for study. So out of 64 or 84 cases, they will ask you 5 judgments. So you will have to write judgments as per the question being asked. This is the basic syllabus of your exam.
Right, sir. So, sir, the basic thing that we know that only advocates on record are authorized to file cases before the Supreme Court of India. So that is something that differentiates advocates on record from normal advocates.
Yes.
So, what are other points of differentiation between an AOR and an advocate?
Practically speaking, practically any advocate can argue in Supreme Court, but AORs have prerogative to draft, file, and argue in Supreme Court because AORs court recognize only AOR. If any advocate came from Kerala, file the case. Just assume that if an advocate came from Kerala, file a case. I'm just making a hypothetical situation. If an advocate came from Kerala and file a case and return to Kerala, how will court trust him if he has not any office in Delhi or surrounding to Supreme Court? So this is why there is a basic necessity being imposed on an advocate on record that you must become an AOR in Supreme Court to draft, file, and argue the case. You are accountable to the court and you are also accountable to the client coming to the final appellate court, apex court. So this is why there is a AOR mandate in Supreme Court. And any advocate can argue, but the necessity is that AOR must present along with the arguing counsel. It may be anyone, but he must be minimum of 1 year of practice to argue effectively in Supreme Court. So AOR presence is required, and he must assist his arguing counsel. And but for drafting, any advocate can draft. Signature of AOR is needed, and Wakalatnama can be signed by referring counsel, who he or she referring counsel may identify the client that the signature has been executed in my presence, because it's not necessary that an AOR signature is being executed in the presence of an AOR. In general, I generally what I do that I ask the referring counsel to you identify the client, and then also I execute the Vaklatnama. And when the client sign in my presence, I endorse that executed in my presence, and then I file the Vaklatnama. So this is the basic duty of AOR, to draft, file, and argue the case in Supreme Court. AOR's registry will entertain AORs only. And if any advocate go to registry to remove the defects or to ask any questions, then he may go through the authorization letter of an AOR. There will not be any problem. You
Right, sir.
must have understood why AOR is necessary to be, for court or for client.
Right. Sir, what kind of cases are filed in the Supreme Court of India? There are so many jurisdictions like Article 142, and there are original jurisdiction like 131. There are
Mm.
criminal jurisdiction like Article 134 and civil jurisdiction like Article 133. But very commonly known jurisdiction is the special leave jurisdiction. Apart
Yes,
from
yes.
these jurisdictions, what kind of cases are quite common in the Supreme Court of India, and what are the most frequently invoked jurisdictions by the viewers?
See, Article 136 is very commonly filed. Besides Article 136, transfer petitions are frequently filed. Transfer petitions means uh, transfer petitions are being filed under Article 139 of Constitution. This is the Article 32 petition and statutory appeal petitions. These petitions are commonly filed. Article 131 petition under Article 131 is also filed, but the litigation between any state government and central government is very low. It is not commonly filed. But transfer petition, Article 136 petition, Article 32 petitions, and uh, writ petitions are commonly being filed. Statutory appeals are also filed. Suppose an order of NCLT is to be challenged in Supreme Court, then it will be challenged under Section 62 of IBC indirectly in Supreme Court. Litigant is not required to go to High Court from the order, challenging the order of NCLT. Suppose somebody has to challenge the order of NCDRC, National Consumer Dispute Redressal Commission, NCDRC. So he may challenge the order directly in Supreme Court. Uh, orders of uh, orders of SEBI, Securities Appellate Tribunal, situated in Mumbai, can also be challenged in Supreme Court under, because the Act provides that, Act of SEBI Act provides that if any order is to be challenged against the order passed by Securities Appellate Tribunal, you don't need to go to High Court. You can directly file in Supreme Court. That's why it is called a statutory appeal. So there, when the Act provides, any specific Act provides that you, under so and so provision, you can challenge the order of Appellate Tribunal to in Supreme Court. You can file civil appeal in Supreme Court, and criminal appeal. There are criminal appeals also. This is the These are the main cases that are being filed in Supreme Court. Article 141, 142 petition is filed in pending cases, not in fresh cases. Article 142 petition is being filed for securing the ends of justice. Suppose two parties settle the case in Article 132, why for 136, through mediation. Then Supreme Court can pass an order under Article 142 and dispose of the case, taking the taking the memo of settlement that has been arrived between the parties, and court can end the litigation between the parties. Article 142 is frequently being filed when wife and husband settle all their disputes in transfer petition. That when any of the parties file transfer petition to get the case filed in lower court from one 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 place to another place. So these are the main petitions that are being filed. A review and curative are also being filed, but it's arising from SLP or any other petition, writ petition. These are the basic cases that are being filed in Supreme Court.
Right. So, sir, we are halfway through this interview. Now, I request my colleague and friend Debashish to come over and conduct the rest of the interview. Debashish, please.
Okay. Thank you, Jyoti Prakash, for the first phase of questions and the interaction that we had just now with sir. So, following up with Jyoti Prakash, last question, I would like to ask you this particular question relating to AOR, sir. What are the relating to AOR and your journey and the important, famous, or significant cases that you have handled till now? So, can you tell us about any most important case like that you have handled or that we should know about that will help our viewers in certain way?
See, I had won a case in which a litigant was debarred from service. Debarred from service. He he had some criminal antecedents, but disciplinary committee had not followed the due process of law. Disciplinary committee did not follow the rules of bank. He was ser- doing service in bank. He was a scale 3 officer in bank, scale 3 officer in public sector bank. He was debarred from service because of long he went for long vacation without intimating the bank. There was medical grounds also, but he could not satisfy the court that why he absented from service for two long years. So he lost the case in High Court also. High Court upheld the termination. Major penalty of termination was imposed on him. He was terminated from service of bank after 13 years of service. So it was not a reportable judgment. But three judge bench decided the matter, and we won the case, and court court finding was that disciplinary proceeding was not followed, due process of law was not followed, service rules of bank was not followed while hearing in disciplinary committee, and court asked the bank to initiate de novo inquiry against the petitioner, my client. This de novo inquiry has been initiated against him, and three judge bench passed this order. It's a recent order. It was very interesting case. I drafted the case and I argued the case initially. I had engaged a senior AOR in this matter for final argument. I'm very much happy, and it was published in Bar Bulletin also. And when the Supreme Court pass an order, it is binding on all the high courts also. To, that what you can do in such an instances. So, matter was listed before the three judge bench, and Dr. Menka Guruswamy argued on behalf of the bank, Canara Bank, and we won the case. We won the case. Client was very happy. It will be a memorable case for me.
That's quite great to know, sir, about this particular case. And even we hear about such cases relating to service matters, and judgments coming from Supreme Court always guide all other courts in
Yes.
India in that
Yes.
light. Now, sir, you just mentioned that you have drafted this particular case that you have just said. So,
Mm.
we would like to ask you that as an independent AOR and
Mm.
running your own chamber, how do
Mm.
you balance the roles of a lawyer, a drafter, an AOR, and then a strategist about the cases? So, how do you manage that?
See, I I handle the case very effectively. I manage my time very effectively. I don't waste my time. I haven't taken adjournment in when I started my independent practice. So I manage everything very diligently. I know that it is my cases will give me reputation. So I take these things very seriously. I don't waste my time. So discipline is needed to handle all the cases. I take briefing from clients also. I ask them to call me after 4 p.m. when I get free, and I take their call. I take their call, and most of the clients do not come physically. They We talk on phone because came from all over the India. They don't come to me directly. If they come to me, I took documents and take a session with them. Courts hour are mainly from 10 to 4 now. So I manage the case. I also draft the cases on Saturday, Sunday. I have some pending work to do. I will do my work tomorrow also. I don't hold works. If any client asks me to file the case and provided me all the documents, I will file the case immediately, subject to payment of the uh, reasonable fees. So I file the case immediately. I am not in a nature to hold work. I am very much proactive in doing my duty, what I have been assigned to. Discipline is
That
needed. Discipline is very much needed to grow in profession.
Absolutely, sir. Even there is a general conception that I hear during my practice journey and
Mm,
interaction with clients. They said that we have holiday on Saturday.
mm.
So I smilingly always say that Saturday is a day when we devote our time in drafting, that we have just pointed out right now.
See,
So
everybody journey is different. I do not go to outside to roam, enjoy my Sunday. I do not go to movies. If I want to watch movie, I watch movies on laptop, manage time. I do not go outside to spend my time. I work. I do my work from home also, and on Sundays. If any pending work is there, I shall do my work, and we will have to prepare for Monday cases listed on Monday also, na. So, so we don't have that much time to enjoy or do anything. But everybody's life is different. Some people have family also. I live alone. So I manage my time effectively. These My work gives me reputation. My works give me money. And it drives me. really drives me, motivates me. Let's say if somebody is paying me, I will have to do his work in diligently or within the time. These things reverberate me in my mind. I do not take things casually.
That's great to know about you, sir. Now, one basic question that one of our viewers has commented.
Hmm.
What is the difference between a normal advocate and an advocate on record before the
Hmm.
Supreme Court of India? So, can you
See,
briefly explain that for the viewer?
see, rewards are needed only in Supreme Court. If you are an, if you are an, if you are a High Court advocate or you are practicing in District Court, you can take help of an AOR if you have any case. If you have any case that is to be filed in Supreme Court, and you are practicing in District Court, like I'm giving a example, you will easily understand. Suppose a wife files a case of divorce petition in family court of Puri or in Kotak or Bhubaneswar. Uh, Husband lives in Bangalore. So husband may file transfer petition in Supreme Court to transfer the case from Cuttack to Bangalore. The divorce petition shall be transferred from Cuttack to Bangalore if Supreme Court judge pass an order to transfer the case from Cuttack to Bangalore. And how will you local advocate will get the such type of case, and he will have to contact the Supreme Court AWAR that I have such so and so cases, I want to file transfer petition in Supreme Court. So he may contact the AWAR, and AWAR needed the summons and divorce petition, and AWAR draft the transfer petition, and local advocate can appear virtually, and he can come to Supreme Court also and argue the case. But AWARs are necessary to draft, file, and argue the case. His presence is required. Anybody can also appear along with AWAR, and non-AWAR can also argue the case. AWARs are necessary only for Supreme Court, not for High Court or any other. But they are recognized in all over the India. They don't need local advocates for filing their cases in Tamil Nadu or Odisha or anywhere, Bangalore or anywhere. AWARs don't need, because Supreme Court rules provide that AWAR can practice in any court, but non-AWARs cannot practice directly in Supreme Court if he has not passed AWAR exam. He may argue, but he cannot sign Wakalatnama. He cannot sign Wakalatnama in his or her name alone. He can identify the client, but petition cannot be filed only with the signature of non-AWAR. AWAR signature is must, because registry can directly deal with AWAR only. Non-AWARs can come from anywhere, anywhere India. And how will registry search search these non-AWARs? Uh, how will how will section or branch, how will court handle non-AWAR? AWARs are needed to be present in court when the matter is listed, and AWAR's office is necessary to be situated within 16 kilometer of radius of Supreme Court, so that if any communication is required to be made between court and the AWAR, communication can directly be sent to the AWAR office. And this is why AWARs are different and AWARs are needed.
That's
This is
correct, sir.
this is what I my understanding about AWAR.
Absolutely, absolutely. I hope the viewer has got the answer in a very brief and accurate manner.
Yes, sir.
Now, sir, we would like to know from your experience of so many years, do you remember any conversation or anecdote or courtroom interaction which you consider was a memorable, or it might be a remarkable moment for you or inspirational moment for you, or might be humorous or witty conversation between you and the bench. Do you remember or can you recollect any such conversation that we can that you can say or tell for to our viewers?
See, I will tell you a recent courtroom anecdote. It was not a very humorous situation. I take court proceedings very seriously. I had filed an SLP against an accused who was convicted under 302 IPC. So there were two petitioners for whom I had filed an SLP. High Court has upheld life imprisonment. Punjab and Haryana High Court. High Court has passed a conviction order and asked him to surrender in court. He was on bail, and court has asked him to surrender. When the High Court decided the criminal appeal, client was on bail. High Court asked him to surrender. So I had filed petition in Supreme Court, and second petitioner absconded, and first petitioner surrendered in district court. So matter listed before the Supreme Court, and 2 or 3 days back it was listed before JK Maheshwari Court. Court asked me that he has surrendered. If a second petitioner has not surrendered, what you have to say? I have told that CGM court has passed an order to issue arrest warrant against him. So my lord, whatever my lord will do, I am ready to cooperate. Court dismissed his second petitioner SLP on behalf of second petitioner, but upheld the petition filed by me for first petitioner, and issued notice to state of Haryana. Court there were argument on merits also, because initially the eyewitnesses supported the prosecution case, but after some lapse of time, the eyewitnesses turned hostile. So I submitted before the court that eyewitnesses have turned hostile, but these two eyewitnesses were the children of the deceased. Court asked me that don't make these submissions, because you also know that these submissions will not help you anymore. But the case was not very much good on merit, because case was uh, case was based on the eyewitness testimonies. So despite that, court issued notice, and I was glad that notice issued by the Supreme Court after concurrent conviction by trial court and high court. It was recently the order was recently passed, and I was very much happy because I had drafted the SLP, and there was not much case was not very much strong. Despite that, in Supreme Court, most of the cases dismiss on the first date of hearing, because you are coming against the High Court order, and if you don't have any good case on merit, court straight away dismiss the case on first date of hearing. So I was glad that court issued notice and posted the matter after 4 weeks. State of Haryana shall file reply, and court will hear both me and the state of Haryana, and then after court will decide the matter on the basis of merit. At least notice was issued. This is the recent case that I have done, and I am happy that I was able enough to get the notice issued from Supreme Court.
Congratulations to you on that, because we regularly hear that 70 to 80% of the SLPs or appeals get dismissed in the Supreme
Yes, sir.
Court. And
More than
roughly
70-80%. It's about 85-90%. Out of 10 cases, they dismiss 8 cases. Only 2 cases notice issued only in 2 cases, and where the case is weak on merit, and there is the eyewitness testimonies, medical evidences, and everything. Section 27 Evidence Act material, there's less scope to get any favorable order from Supreme Court. But despite that, Supreme Court issued notice. Supreme Court could have dismissed the case on the first date of hearing, but it issued notice. Court wanted to hear the opposite side also. That's why they issued notice. And court must have reached to a conclusion that case is worth for issuance of notice. That's why they have issued notice. So they must have got an idea that case is good on merit. That's why they have issued notice.
absolutely, absolutely, sir. Now the next question of mine is that who are or were the eminent members of the bar and bench, both at national and state level, whom you consider as your inspirations? Or if you can tell us about any specific instance with them or any lesser known fact about them, then it would be great for our viewers, sir.
See, I I generally hear the lectures of Arvind Datar and Rohinton Nariman. Both are mind-blowing legal luminaries. Arvind Datar is a senior advocate practicing in commercial side in Supreme Court and also in also in Tamil Nadu, Madras High Court. That I used to listen his lectures on basic structure doctrine or article fundamentals, right? And I also used to listen Rohinton Nariman's lecture. The good thing about I'm very much impressed about from Rohinton Nariman because he don't use paper. He don't use paper while delivering address to the audience. And he's very good in commercial side. You can take legal opinion, you can take any opinion from Rohinton Nariman, even after he has been retired from Supreme Court. And he is very thorough with the subjects. I'm very much impressed with him. He knows about the world history, he knows everything, almost everything. Many of the people may not have known that Rohinton Nariman was called to the Congress of Religion in Chicago. He was the only person after Swami Vivekanand who was called to World Religious Conference in Chicago. It was incident of 2022 or 2023, but, but he was the only second person in his till now in the history of India that who has been called to World Religious Conference to deliver a lecture on religious issues. I am very much impressed from Rohinton Nariman and Arvind Datan. Another of my favorite is Mukul Rohtegi. Mukul Rohtegi, the good thing about I learned from him that he simplifies the case in a very lucid manner. He simplified the very complex case in a lucid manner and addressed the cause. So it will be easier for judges to understand the matter. What you have to do is to easy the work of judges. You have to simplify the cases in a most easiest manner so that judges could understand the matter and you must assist the court in a very proper manner so that they can pass a reasonable order after hearing both the parties. So in general, I am impressed from these three advocates in Supreme Court. I also used to listen about from there are so many young counsels also. J. Sai Deepak is also argues very well. J. Sai Deepak, recently I heard in Sabrimala review cases also. So I inspire from them. And it will take long time to argue like them because they have worked very hard in their profession. It's not a one night job. They have taken they have taken very arduous work. Gopal Sumanam is also very good advocate. He is mainly barrister in UK, but I have heard his argument physically and many times in High Court and Supreme Court. They, they are very thorough with the matters. They they prepare very well before arguing the matter. They have worked very hard, and this is why their fees is high. And these are the advocates who are very much sought for. The litigants can want to engage them at any cost. I am very much impressed from these legal luminaries.
That's great to know, sir. Also, I would like to tell our viewers that we have a session of Justice Nariman on freedom of speech and expression. So we have
Yes.
hosted that. So that is there on our YouTube channel. We have also had a chance to interact with Arvind P. Datar sir, and humorously, I had asked him that what one trait a lawyer should have, and he had said that wake up at 5 a.m. and start working, and every
Because
day yes,
they
sir.
have worked very hard. He has spent so much time in library. He used to write documentaries. He has written a book on so many books. He has written books on constitution also and written book on commercial law also. Nani Palkiwala, Courtroom Genius, has been written by him on with assistance of Soli Sorabji, and they have done a lot of research while drafting that book.
Absolutely,
Datar,
absolutely.
Datar is an amazing advocate. Commercial side,
Here,
taxation side, he can argue on any side.
Absolutely, sir. Also, he had advised me that me and Jyoti Prakash that always have a physical exercise routine in your
Mm,
daily life so that
mm.
you will stay fit. So these two advices stay with me and Jyoti Prakash always for this.
Because litigation is a very grueling profession. Now you will have to stand in court for long. Not all advocates get seat for sitting, get any space for sitting. So and weather also impacts a lot. In district courts, you have to do so much bhagdor. You will have to be on your foot always. You will have to go from one court to another court, and there are so many procedures involved in district courts also. So it's a very tough task to be in litigation. And after come from Supreme Courts to office, you will have to spend some time in preparing for the cases list on next day. So where do you have time to spend on yourself or your family? You will have to. You have don't have any option except to remain fit. You will have to you have to eat healthy, and you will have to mentally physically fit to effectively handle the case. It's very much necessary.
Absolutely, absolutely, sir. Uh, Now, one question that is coming up in our chat is our viewer is asking that how a common man can
Mm.
contact or approach an AOR like you for giving cases directly.
See, list of awards are available in Supreme Court website, and we all awards phone number, including myself, my phone number and email address are available there. I cannot provide phone number or email address current session, but I do not provide any my phone number or email in any of the session where I go. The client may search my name on award list and then contact me, and it's publicly available on Supreme Court website. He may engage any advocate, and, and client can take client can contact me on LinkedIn also if he or she wants to engage me on LinkedIn for any case in Supreme Court or in Delhi courts. I mainly practices in Delhi, and that's why I take up all cases of this.
Absolutely, sir. Now, sir, as you mentioned about LinkedIn, how do you see that LinkedIn is a platform to connect with professionals like you and every law student who is seeing this particular series? What is the importance of LinkedIn and connecting with professionals like you? And what would be your advice to the young law students on this aspect?
See, you will have to be visible on LinkedIn. People must recognize you if you are a practitioner or you are a final year student. You may randomly post on LinkedIn. You may write an article. You may share your views on legal issues. But don't offend anyone. Don't offend judges. Don't offend any general community or caste. Be very cautious while posting on LinkedIn. Don't indulge in controversy. This is my suggestion to my young colleagues or anyone. Be very serious. Be very responsible while posting on LinkedIn. Don't write any controversial post. And I accept the connection request of anyone belong to law, who is a law student or in legal profession or any problem. I don't discriminate any person. Receive the connection request, and I try to reply everyone. Send message to me on Messenger, LinkedIn Messenger. I reply everyone. There is no any question left unanswered on LinkedIn. If I get a query from on LinkedIn Messenger, be very careful. You will have to be visible on LinkedIn. I also randomly write post on LinkedIn what I feel about my profession, my people, what I read, what I read, or what I understand about a judgment. What are my views about a judgment? What what I listen or heard while hearing a lecture of Rohinton Nariman, or what I learned from Rohinton Nariman, or Arvind Datar. I randomly post things. Legal, mostly legal issues. I write on mostly legal issues. I can write also on socio-economic issues or what is happening in economy or Indian economy. But I don't want to write political post. I remain very careful that my post do not reflect that I am being political inclined to any party or anything. Because I'm a council now. After all, I am a council. I have to act very consciously. This is my approach. I have good followers on LinkedIn. I write naturally. I write carefully and I write honestly. I do not copy paste anyone's post. You will have to be very natural while posting on LinkedIn or any social media. Don't copy paste. Frame your own post or content and then post. There will not be any problem. I do not indulge in too much conversation in comment section. This is my basic principle. I do not in a habit of targeting anyone. I'm not in a habit of dragging things because LinkedIn now is not that platform that I will have to show my argument skill with anyone. I'm a senior practitioner. It's getting my 12 years of practice. I know these things that I will have to not to indulge in any controversy. I'm a Supreme Court practitioner. I know my responsibility. So everyone should act responsibly. That he is a legal professional, or he will become an advocate 1 or 2 years later. So he should maintain that composure or demeanor that he is a responsible person. He must act responsibly.
Absolutely, sir. Now, LinkedIn has become, in today's era, the most important platform for everyone, every professional. He might not be in legal field, to stay connected professionally with everyone, recruiters, clients, corporate CEOs, and everyone. So that's a great advice that you have given. Also, I would like to mention that you are too humble to say that you have good amount of followers. We must tell our viewers that sir has more than 30K followers, and he posts regularly on insightful topics of law. So everyone can follow him and check out his posts for learning.
Thank you, thank you.
Also, sir, you have mentioned about Gopal Subramaniam, sir, and one fact that I just recollected right now is that
Mm,
Gopal Subramaniam was also nominated for Supreme by the Supreme Court Collegium to be appointed as a judge of the
mm,
apex court in 2014.
yes,
Now,
yes.
if yes, now if he would have accepted that, he would have served as the 49th Chief Justice of India after the retirement of Justice N.V. Ramana.
Yes, yes.
So,
The proposal is stuck in political controversy. That's why
yes, sir.
it couldn't
Yes,
be.
some objections came from government. Some
Yes, yes,
initial objections were
yes,
there.
yes. But he's very good counsel. I have seen him that he argued IPR cases, he argued arbitration cases, he argued insolvency cases, he argued constitutional cases. You can ask him to argue any type of cases. He will argue extempore for long many hours. This is the quality of good advocates. And I was seeing that he was arguing before the 9 judge bench in a Sabrimala review cases, and he argued for quite long time without, and he answered all the questions of judges. This is the quality. I am really amazed by their presence of mind and their thorough preparation, because you cannot recollect your what you have what you have prepared or what you have studied. They argued extempore, whatever they have come to mind, and they argued in a quite good manner. They act responsibly because constitutional bench hearing are being broadcasted live all over the people from all over the world watching them. It's very much become very sensitive to watch them arguing before the nine judge bench and answer them effectively. It's not an easy task. You will have to be very confident and very thorough with the subject matter you are arguing. And these attainment came after so many years. It's not a one night work or 1 or 2 years practice. Such type of confidence came after so many years.
Absolutely, absolutely correct, sir. One of the law student who is viewing us right now is asking that how internships are relevant for law students and what qualities do you search for while hiring an intern or a junior?
See,
So,
I generally prefer final year students for internship because final year students will be able to help me in my cases. This is my basic principle. I do not want to engage a second year student or third year student. I prefer final year student because final year student can only understand the cases I am handling. So my basic criteria, he must be a final year. I do not generally go into the name of the college while selecting a candidates. And this is my basic principle to decide or choosing the candidate for internship. And what about answering the question of relevancy of internship? See, internship are very much necessary to understand the practical realities of courtroom proceedings and how litigation intricacies, how an advocate files his cases, how documents are being prepared, how listing proforma is being filled up, how annexures are being arranged. You can sit with a clerk or you can sit with the drafting counsel. How list of dates are prepared. You can get to know about these things only when you are doing an internship because in general these things are not being taught in law colleges. I'm talking about very practical things. So courtroom, since I'm a litigating lawyer, I can only let people aware about the practice, my practice sides, how we argue the cases, and then can only understand when they watch me arguing the cases. I can make him understand that what happens in SLP, what are the stages when a cases is being filed or listed before the court. So interns can learn too much through internship, through while being with the practicing lawyer. While being with the practicing, they can learn drafting also. They can assist the clerk also in preparing the cases for filing in high court or any tribunal or any court. Practical realities, intern can learn only when he is in he is with associated with any advocate. I understand that
very true.
internship is very much necessary.
Very true, sir. Also, along with internship, we always come across a fact that judgment reading and participating in moot courts are
Mm,
also important for law students and building a good career
mm,
graph as a law
mm,
student. So,
mm.
what should be the approach of a law student while reading a particular judgment? And what is your take on participating in moot courts?
See, I will answer your question part wise. Judgment reading is very much important. I realized this thing quite a lot, quite a late. I realized the importance of judgment reading after when I started preparing for UR exam because there is a complete paper of leading cases that are being asked in UR exam. So what I have done is that I have taken subscription of Live Law. I randomly check their news update, and if I came across that any case important for me, I make a notes in my diary, and, and I read the judgment and make a notes of the in my diary. And how to read the judgment? I have my own strategy. I read the facts, then I read the petitioner counsel submission, then I read the opposite counsel submission, then I read the issues framed by the court, then I read the ratio, and then after I read the conclusion part. This is how I strategize or compartmentalize the long judgment. If I came across a 200-page judgment that I have to read, I do not read complete judgment. This is my basic honestly honest 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 view about how I read a judgment. I I strategize the case. I strategize the judgment in such a way that I have to know what is the basic facts, how the cases originate, and how it reaches to Supreme Court or High Court. I know the basic. I read the basic facts. Then I read what is the petitioner counsel submission, what is the respondent counsel submission, what are the main questions of law that court has to decide. Then I know, read the ratio. I elucidate or I extract the ratio decidendi, reasoning of the judgment. What is the reasoning behind passing the judgment? Then I read the conclusion, whether court allow the appeal or whether court dismiss the appeal. This is how I read the judgment. I make a notes on important judgment in my diary. I do not read all the judgments. Whatever important for my cases or my domain of practice, I make notes only of them. Suppose I don't have any practice or cases of income tax, I do not read such cases because there are so many materials on the internet also. Now, I need to spend time carefully or sparingly. So, what is relevant and important for me, I only read those things. I do not read everything. I will have to manage my time effectively. Na? So this is how I read the cases. And second, answering your second question, moot courts are very much important because you will you get to know how cases are being argued, and you will be judged by the moot court judges. So it's not very much equivalent to the courtroom argument or courtroom hearing, but you will get a tentative idea how moot courts are being held and what are the topics being given in moot court hearing. So moot courts are more or less important, but not compared to courtroom hearing. If you sit in a courtroom in a CGM court or a high court judge or in a court of district judge or in a court of Supreme Court, I do not ask or do not tell or do not advise anyone to come directly to Supreme Court because Supreme Court practice and procedures are quite different. A fresh candidate will not be able to understand the argument being done in Supreme Court. You will not understand. It take me 4 or 5 years to understand leave granted matters or after notice matter. I do not understand these things in my early years of practice. It's only after becoming a bar I get to know what is leave granted matter or how cases are being listed in Supreme Court. But a fresh candidate can understand the argument or hearing in district courts. He may ask anyone, and counsel practicing counsel assist in every way. So this is the my basic approach, my basic understanding about moot courts and reading the judgments.
That's very true, sir. And it is really enlightening for our viewers and law students who are watching the video right now. The next question would be relating to drafting, sir, because drafting is a major stakeholder or a major part in our day-to-day journey in litigation.
Hmm.
So, what would be your tips for the law students who want to join litigation and who want to draft a petition very meticulously?
See, suppose a client come to you. He gives you certain documents to file a writ petition. So first, what you have to done is to take a brief from him. Take a brief from him that what are your grievances, why you want to file so and so cases in High Court or anywhere. You will first have to arrange the annexures list of documents that he has provided to you. My practice strategy is that I take a session from client. I understand his case or her case, that what how he is agreed by the action or inaction of the respondent, and whom he wants to file case against them. So I understand his cases appropriately and what remedy he wants from court. And accordingly, I draft the prayer. So my strategy is that I first prepare list of dates and events. I arrange annexes chronologically from starting date till last date. So I arrange the annexes chronology, then I prepare list of dates and events, then I prepare synopsis, and then after I draft the petition, whether it is plaint or whether it is a writ petition or whether it is SLP. I first draft list of dates. I get an idea that how events take place chronologically, how what is the sequence of events, and this is how I draft my petition. In Supreme Court, you will have to draft question of law. What provisions are being violated, are being overlooked or ignored by the High Court? I will have to apply my mind that what are the lapses in the High Court order, and accordingly I will have to draft my questions of law. See, Supreme Court drafting is all about format based drafting. Supreme Court SLP has 8 paragraphs content, and you will have to draft accordingly.
Very true. Very
Mainly,
true.
I will have to draft properly a synopsis, question of law, and grounds, legal grounds, because Supreme Court is constitutional court, na. So I will have
Correct.
to show that why court need to issue notice under Article 136. See, according to me, drafting a plaint or fresh cases in district court is difficult compared to Supreme Court, because Supreme Court you have a format based drafting. You will have to apply your mind that where High Court has erred, or why which provisions of High Court has overlooked, how High Court has interpreted the provisions, how High Court has dishonor the Supreme Court judgment or overlook the judgment in the facts and circumstances of the case. And I will have to cite only these things in my synopsis or legal grounds, and accordingly I draft my cases. But first thing is that you must command your facts very good. If you don't have any command on your facts, you are not very much confident about the facts, you cannot draft properly. So first get aware with the facts of the case from your client, get all the documents, ask so many questions from client, be very confident about the facts of the case, then you may apply your mind that which provision is applicable in the current facts and circumstances of the case, and what will be the prayer, and accordingly you can draft your case. This is my strategy of drafting the case, and no any judge from district court, High Court, or Supreme Court objected in my drafting that your drafting is bad. No any judge till now, no any judge objected in my petition that you have drafted a bad petition or not drafted a good petition. My cases have been dismissed, but people praise my drafting. I am very much satisfied with my drafting when I draft the cases. I I I take time, but I draft my cases properly.
Very true, sir. Drafting is really important to
Very
build the
important.
base of a case.
Because
By that only,
if you omit a crucial facts, court will not grant you relief. Court will rely on your pleadings, and court will ask you where you have submitted, where you have write the facts you are addressing to the courts. And if you unable to satisfy the court that these thing I am submitting in court is not written in my petition, court will dismiss my case. So what you have to write and what you don't have to write, you will have to very careful, because client interest is in your hands. Client is very much cautious while engaging you. Client interested you. Client gives you your case on the bona fide belief that you will handle the case properly. So you are very much responsible for the outcome of the case. The client
absolutely,
advocate
absolutely.
must handle the case carefully. Don't be casual. Must not be casual.
True, sir. And that will also help you build your case and argue effectively in the court.
Yes,
So
yes.
that makes
It-
drafting very much important.
my understanding till now that confidence arises when you argue the case. Drafting is important, but when you appear before a High Court judge and Supreme Court judge, and you address the court, and you answer the court or his query, you get confidence. When you argue for 10 minutes or 20 minutes final argument, and you conclude your argument, you will very satisfied that I want what I wish to submit, I submitted. And then after, irrespective of the result of the case, you will be very satisfied and contented that you have tried your best, and leave it on the judge. There is no any incompetency within myself that I able to mm, do not able to address the court properly. You must be very confident when if you are well prepared.
Absolutely, sir. Now, sir, one question for students, law students who are not studying in NLUs. So, what would be
Hmm.
your advice to those law students who could not make it to NLUs or other top law schools but want to excel in this profession?
See, you must take your college college curriculum very seriously. Very seriously, you make your hand notes of every subject. It will help you in long run. You must prepare your hand notes of every subject, every topic. You prepare a list of judgments that you came across frequently, or you came from the source of live law or bar and bench. You must prepare your hand notes. If you prepare your hand notes, you will excel in long run also. So if it is not necessary that you study from NLU definitely gives a good exposure, but it's lastly it all about the competency of candidate. If any candidate s- pass pass his exam with a distinction, or he will be he will grow very astronomical heights. I don't have any doubt about it. And second thing, after came into profession, you must be very serious about the profession. The cases come to you, or when you are associated with an advocate in his chamber, you must be very proactive with the work he assigned to you. Suppose he asks you to file a plaint, so you must draft the plaint in proper format. You must present all the case in chronology. You must know that how the court fees is calculated. You must know what is how suits are valued. You must know how to frame a prayer, how to draft an affidavit. These are the basic things that you must know. And if you know these things, you will draft properly. If you're not able to understand these things, you must ask your senior, or you take assistance of your colleague who is associated with you in chamber. But you should have that willpower, that I want to learn things. If you don't have any willpower, why anyone will help you? So first you must help yourself, then able people will help you. You must be very serious about your profession, that you will to have to earn your bread and butter from this profession. You will have to feed your family, you will have to sustain in this profession from these work. This is your Lakshmi, or this is your god. You will have to first understand is that this your work is providing your reputation in profession, and you must your work is providing you your earning. You earn from this profession, so be very serious about the profession. And if you are serious with in the profession, you will not take things lightly. So you must be inquisitive. You should have reading habit of reading also. You should have habit of making your own notes, and you must be able to work very hard. If any council is asking you to go and file a case immediately in an urgent situation, you should not hesitate. You must go and with the clerk and take help of the people in the profession to file a case. At least you will know that how cases are being filed in case district court or high court or supreme court, how to remove the defects marked by the registry, how the cases are cases are being listed in the court. You must do know these basic things, because client gives you money when the cases are being listed and when they get favorable order. Client has some expectation from you. You must be very practical about the realities of the legal profession. You can definitely grow in profession. You should have that willpower, that I will have to do all types of cases in district court and high court or tribunal. You must not deny any cases just on the account of fees. That if any pauper or any poor people come to you and he is asking you to draft my application, bail application in 5,000 rupees or 3,000 rupees, you must not deny your cases, because he might not have that money. And because if you deny the cases, a bona fide client may not be able to enjoy his freedom of right to live with dignity, or freedom to interact with the family if he's in jail. So you must file his cases, and you must not deny the client case just on the account of low fees. You will have to, because you cannot be a very much peculiar when in your initial years. You must take the cases, every type of cases in your initial years, and you will have to active, you will have to socialize with the people, because people will give you cases. If you don't go to case courtrooms and you sit in your home, then court people will not come to you. If you don't interact with the people or your societal surroundings, you must interact with the people of your society or your fraternity members. They will give you the case. They will trust you that you are able enough to handle the cases. Then they will definitely give you cases. And if you are diligent, if you are hardworking, you will handle the case properly. So you must act honestly and in a disciplined way.
That's a great piece of advice, sir. Now, one of our viewers is asking that how the pro bono practice at the Supreme Court actually works, and what is the process by following which a poor person can approach an AOR or an advocate in Supreme Court to file a case there.
See, I am a panel advocate in Supreme Court Legal Services Authority. The client has to satisfy certain criteria. There's He has no any income sources, or his income below certain level as prescribed by the court, or some rules. And he or she may apply to Supreme Court Legal Services Committee website and fill up the forms. He or she may be a woman, or he or she may be a any sexual victim, or he or she may be the earthquake victim, he or she may be a inanch transgender. These people are eligible for legal aid in Supreme Court. And the Supreme Court Legal Services Committee has a panel of AORs, and Legal Services Committee assign the cases to the list of AORs, and AORs take up the cases. And the client will have to first apply the cases on the Supreme Court Legal Services Committee and fulfill the eligibility criteria for a pro bono cases. So, and the client do not need to pay any fees to advocates directly. Advocates are being paid from the Supreme Court Legal Services Committee at a nominal fees. We take up the case and argue the case, draft the cases and argue the cases. This is the basic way to file a case in Supreme Court when a client is very poor and want to get the cases handled pro bono. Legal Services Committee is institutional authority who handle the case pro bono.
That's very enlightening, sir. And I hope this addresses the question. Another question that is coming up is the Supreme Court is piled with thousands of cases and pending matters. So, from your ground level experience as an AOR, what one structural change would make the biggest difference and reduce the pendency of cases in Supreme Court?
Mediation is important. If any party willing to settle the cases in mediation, high court or district court refer the cases to mediation and settle the matter. This is how cases can be prevented to be filed in Supreme Court. In Supreme Court pending cases, when a SLP is filed and court refers the matter to Supreme Court Mediation Center, and parties are able enough to settle the matter through the help of mediator or the councils, cases can be settled and court can pass appropriate order uh, se- settling the cases and disposing the cases. This is how pendency can be reduced. This is my basic and precise answer to your question, that mediation is very much important to reduce the pendency of the cases. And second thing is that councils do not take adjournment. If the council, I am not in a habit of taking adjournment. I haven't taken adjournment in my cases for the long many years. I am not in a habit of taking adjournment or passover. To advocate must not take adjournments when the case is listed in court, and it not only depend upon one counsel. It should depend upon the other counsel also. Both counsel, petitioner and respondent side counsel, are responsible to reduce the pendency of the case. Don't take ground frivolous ground for adjournment, and these are two basic necessities to reduce the pendency of cases, in my understanding.
Very true, sir. Nowadays, mediation and then negotiation, these things are taking boost in India.
I am
For
also undergoing training, mediation training in Supreme Court. Na? So I came to know that mediation can resolve so many cases, almost every cases. There are some exceptions also that cannot be referred to mediation, but almost every type of cases except cognizable offences can be settled in mediation. Public policy matter cannot be settled in mediation. Service matter cannot be settled in mediation. But there are so many civil disputes that can be settled in mediation. Matrimonial disputes can be settled in mediation. Courts are flooded with matrimonial cases. If, with the help of a trained mediator, cases can be settled in mediation. Court can pass effective order to dispose of the case. Lok
very true,
Adalat,
sir.
Lok Adalat, frequently conducting Lok Adalat can also reduce the pendency of case. So government is also helping, and court is also proactive in disposing of the cases.
True, sir. True, sir. Now, as we are approaching towards the end of our talk for today, I have three rapid fire questions for you, sir, that I would like to ask you. Uh, the first one is one case that permanently changed how you think as a lawyer, sir.
Manish Kumar versus Canara Bank.
That's
This
if you
case,
can
this
tell.
case, is,
Yes,
this I have discussed this case in this session also. This was related to a terminated bank employee cases.
yes,
I handled the cases from in scratch to end on my own, except final argument. And this case is very will remain in my memory for long. I have got a good judgment in this case. I am able to secure the reinstatement of a terminated employee case.
great,
So
sir. One
this
habit,
case,
yes, sir. Yes, sir. Now, one habit you wish you had built earlier in your career, sir.
reading is very much important. If you inculcate the habit of reading, you will grow long. You will grow long.
True, true, sir. Now, sir, if you were not a lawyer, what would you have been?
Banker. I want to practice in. I want to profess. I want to be a serviceman in a bank, public sector bank.
That's great. That's great, sir.
Mm.
Uh, now, sir, it's all the questions that we ended to ask, and all the viewers, they have also asked so many great questions, and it was a great interaction between you. I would like to call Jyoti Prakash on the stage as well here so that we can conclude our session on a perfect note.
Thank you. Thank you.
Uh, I think there is some problem in joining. Sir, it was a great interacting with you, and we are really great as a team, Lex Cognoscenti, that you gave so much of your time out of your busy schedule to us, giving and interacting with us and with our law students. In this session, you have given so many advices that are to be followed by the law students, advocates, and someone who is willing to take his journey as an AOR. So it was an insightful session, sir, and we are really thankful. We are really grateful that you have taken out time for us, sir.
I am also grateful to that you people gave me opportunity to interact with so many people in a live session. So I'm thanking you, and my warm regards to both the co-founder of Lex Cognoscenti, and thankful. I will always be grateful to both of you. My best wishes to both of you in your future endeavors.
Thank you so much, sir.
Thank you, sir.
Thank
Very great.